Good evening. I'd like to welcome you all here tonight to Longmont's Landlord Symposium, our second of 2010. We usually have 3 landlord symposiums a year, and this is our second of 2010. Before we begin, I just want to talk to you a little bit about my office, the Division of Community and Neighborhood Resources. My name is Susan Spalding. I am the Community Relations Specialist for the City of Longmont, and I coordinate the mediation program for the city. As part of my job, I also run the Landlord Symposium because I would say about 70% of my work involves working with landlords and with tenants through our office. I have outside a new edition of our landlord handbook that the city publishes. It's full of good information. It's free. If you want to pick some copies up for your tenants or for yourself, you're welcome to take some. One thing I want to point out in the new edition of the landlord handbook is that we have information on crime-free multi-housing, which is a new initiative that the police department and in conjunction with code enforcement and with the Department of Community and Neighborhood Resources is working with landlords. Right now we're working just within the Midtown section, but we hope to expand the program to all of Longmont eventually. There's a brochure on the table outside. Please pick one up, read about it. If you have any interest in involving your rental property and crime-free multi-housing program with the police department, please feel free to call Officer Sarah Arney. One thing that we do also, just to let you know, is that we work with the eviction hearings at the courthouse. We always have a mediator at the eviction hearings. And if any of you need to talk about evictions, or if your tenants are confused about evictions, you're free to call our office and we'll be glad to walk either landlords or tenants through the eviction process. We do have our next Landlord Symposium planned for September 23rd. It's going to be on fair housing, so if you all will leave your email address for me, I'll be glad to notify you of upcoming symposiums. Tonight, our symposium for the first time is going to be broadcast and put on the internet. Beginning with the September symposium, we're also going to be broadcasting these symposiums so that they're available to a broader audience. Our first speaker tonight is Nick Robles. Nick has been a Latino community health specialist for the Tobacco Prevention and Education and Prevention Partnership of Boulder County Public Health for 3.5 years. Since returning from the Peace Corps as a volunteer in the Dominican Republic, Nick's been developing relationships and building trust to fulfill his goal of eliminating health disparities in Boulder County. He has a large experience with smoke-free housing policies, and he played an integral role in working with Boulder County Housing Authority and with the in-between and implementation of smoke-free policies. Nick?
Good evening, and thank you, Susan, for the introduction. And thank you, Susan, for giving Boulder County Public Health the opportunity to come share a little bit of information regarding tobacco in multi-unit housing. Like Susan said, I've been working with Boulder County Public Health for about 3.5 years, and our tobacco program is actually paid for by the tobacco tax. So anytime somebody buys a pack of cigarettes, about 16% of the 84-cent total is going towards programs like ours, which are working to help reduce exposure to secondhand smoke, help people that smoke have the free resources to quit smoking, to prevent youth from starting to smoke, and also to work especially with some of the populations that have a greater burden related to tobacco. So tonight, I'm going to go through more or less the case for smoke-free housing, and I'm going to talk a little bit about maybe the economic reasons, the legality, the market niche, and then a volunteer with Boulder County Public Health, Carrie, she's going to talk a little bit about some of the research that she's done related to smoking in units in Longmont, and she's also going to talk about the implementation. And then we're lucky enough to have a couple individuals from the in-between talk about their experience when they went smoke-free. Okay, just so I have a better sense of who we have in the audience, I was just hoping if you could raise your hand if you've ever had a resident or even a friend talk to you complaining that smoke from someone's unit is drifting into their own unit. Okay, thank you. Also like to know if there's anyone here that manages a building that's already smoke-free. Okay, so we have a couple, and I think it'd be great to get their perspective later when we open up for questions. Okay. So I guess our motto in smoke-free housing is good for business and good for health. In Colorado, I would say about 3 years ago, it was pretty difficult to find smoke-free buildings, but there's been quite a bit of movement, even at the national level as well. California, Michigan, Portland have really, or Oregon, have done a lot of work in terms of really demonstrating the legality and just that this is something that residents want. And Colorado's been able to benefit and pretty much copy or use a lot of the same model lease language, use a lot of the same tactics in terms of education and implementation. So as you can see in Colorado, there's already over 800 multi-unit residential communities that are smoke-free, and we already have 13 housing authorities that have smoke-free communities. And of course, we see Boulder County Housing Authority and the City of Boulder, the Boulder Housing Partners. They have a few communities that are smoke-free, and they just passed a resolution. So in September of next year, all their units are going to be smoke-free as well. And Longmont Housing Authority has a few communities that are smoke-free, as well as Estes Park, Fort Collins, and Loveland, and a few others. Oops. Okay, so residents appreciate non-smoking communities. This picture is of a 309-unit building in Inglewood, and it opened in 2008, and it opened as a non-smoking building. Even the campus is non-smoking. And Alicia Parrish, the marketing coordinator, stated, "The feedback from prospective and current residents has been overwhelmingly positive, and they really appreciate that tobacco smoke will not enter their residences when someone smokes inside their units or on the property. Even people who smoke are renting apartments here because they see it as an incentive to quit smoking." So a non-smoking policy helps save money, reduce costs of cleaning and repair in terms of carpeting, furniture, fixtures, window treatments, walls. And also it can help lower some of the utility bills. When the Marriott hotels went smoke-free, I think after a year-long assessment, they were able to see that they reduced their energy costs by about 30%. Okay, so cleaning a smoke-free unit is less expensive, less time-intensive, probably only requiring repainting the walls and carpeting, shampooing. And of course, these numbers are just estimates. They could be much higher, much lower. As we can see, it's really difficult and expensive to try to eliminate the tobacco odor. Could require, to truly eliminate, could require having to replace some of the fixtures, appliances, taking out the carpet, or deodorizing the building, redoing some of the cabinets, countertops, or having to to work on the windows or the floors. So as we can see, it can be quite a bit more expensive, at least 2 to 4 times more expensive when you're turning over an apartment that was smoked in. Also, a non-smoking policy improves value of the property, lowers the costs, and improves health. One incentive is, of course, everyone has to work individually with their insurance provider, but it is possible to get lower the insurance premiums because you do have a smoke-free building. Also, there's less damage caused by smoking, so that helps improve the property value. It also reduces time spent on smoking-related complaints, and we saw a few people raise their hand in terms of those who have residents that have complained about smoking drifting into their units. And it also helps protect the health of residents and workers. So between 2006 and 2009, independent market research firm conducted a survey with residents and landlords, and they did this in Portland, Oregon, and Clark County, Washington. And they talked about the advantage of being able to advertise and have a smoke-free building. And what they stated was, while we have certainly seen some exciting market opportunities for businesses over the years, we rarely see such obvious ones. Frankly, if a private property management firm had conducted this research, it might be tempted to keep the findings confidential to gain an initial competitive advantage. So we see from this quote that there is a demand for smoke-free housing. I'm going to go a little bit over the statistics that we have for Colorado. So there's about 82% of Colorado adults do not smoke. And from the surveys that they've conducted in Colorado, we see that about 85% of Colorado households report having rules that don't allow smoking inside their homes. Also, most residents, including low-income and minority populations, prefer living in non-smoking environments. We also have some statistics from both locally and throughout Colorado. And in 2000, it was the November and December of 2007 that we sent out the surveys with Boulder County Housing Authority residents, and about 61% responded to the survey, and 66% were in favor of implementing a non-smoking policy for all the units in their housing. And also we see the in-between did a survey as well, and as you can see, most of the numbers are between 60 and 70%, with the exception of Alamosa, who had 100% response, and they had about 62% of the residents that lived there participated in the survey, and every one of them was in favor of a non-smoking policy. Happy renters stay longer. So a survey was done in Minnesota, and it showed that 95% of owners or managers who have prohibited smoking in both large and small apartment communities reported that the no smoking policy either increased occupancy or had no impact. Okay. And I would say Colorado, Colorado residents expect non-smoker consideration. When you think about it, smoking is not allowed in workplaces anymore. You can't smoke in restaurants or bars, and most public places are already smoke-free. Secondhand exposure can happen through doors, windows, and through the ventilation. Most of the landlords, or actually all the landlords, according to the study that was done in Oregon, that implemented non-smoking policies, none of them actually went back to allow smoking. The quote says, "Not one of the landlords who prohibits smoking regrets doing so, and none are considering going back to allowing smoking in any unit where it has been prohibited. Many said that once they tried it in one property, they quickly wanted it in all." Now I'm going to talk about the legality. Non-smoking policies are legal. So in 2006, Colorado passed the Colorado Clean Indoor Air Act, and that has a provision that states that landlords may make any part of the property non-smoking, and also with that legislation mandates that smoking be prohibited in all indoor common areas. Non-smoking policies are not discriminatory. There's no legal or constitutional right to smoke. No court has ever recognized smoking as a protected right. And non-smoking policies do not violate any fair housing regulations.
When you talk about smoking, are you talking about regular tobacco, or are you also talking about the marijuana situation?
Okay, yeah, I should have made that clarification before. The question was, when I talk about non-smoking policies, am I talking about all kinds of smoking or tobacco or medical marijuana? And I'm sorry I didn't state that before. This presentation is specifically related to tobacco smoke. So I'm interested to hear what the lawyer Judd has to say about medical marijuana and regulations. And we can see that these policies are not discriminatory or in violation of anyone's rights, because that's why we already have smoke-free bars, restaurants, public places. And we'd like to remind everyone that this issue it's not about the smoker, it's about the smoke. So it's not targeting individuals, it's just a behavior that one can change. And we have some guidelines regarding Section 8 housing. From the Office of HUD or the Denver HUD office, Marcy stated that currently there's no statutory or regulatory provisions related to smoke-free housing, but it's also stated that owners may adopt reasonable house rules related to safety and habitability of building and comfort of the residents. And the U.S. Department of Housing and Urban Development in 2009 stated that HUD strongly encourages public housing authorities to implement no smoking policies. Now we're going to shift over to the health issue. This is former U.S. Surgeon General Richard Carmona, and he says, "The scientific evidence is now indisputable. Secondhand smoke is not a mere annoyance. It is a serious health hazard that can lead to disease and premature death in children and non-smoking adults." Secondhand smoke causes death and disease. So in that same report, the Surgeon General stated that there's no risk-free level of exposure to secondhand smoke. And secondhand smoke is responsible for nearly 50,000 deaths in the U.S. every year. And tobacco smoke contains about 250 toxic or cancer-causing chemicals. As it's in the same category as asbestos, secondhand smoke, and some of the examples of the cancer-causing chemicals are arsenic, which is used in rat poison, formaldehyde, which is used to embalm cadavers, and butane, which you find in lighter fluid. So this comes from the American Society of Heating, Refrigerating, and Air Conditioning Engineers, and they're the ones that set the industry standards for ventilation. And a quote from them is that at present, the only means of effectively eliminating the health risk associated with indoor exposure is to ban smoking activity. So about 50% of air in one unit is recirculated throughout the building. And now there's also the risk of fire with allowing smoking in buildings. A smoke-free building is safer for children, adults, seniors, and pets. Cigarettes cause an average of 5% of all residential fires in Colorado. And according to the Colorado State Fire Chiefs Association, in 2006, residential fires were caused, in terms of residential fires caused, 39% of all residential fire fatalities caused by tobacco smoke, 7% of residential fire injuries, and 3% of all residential property loss. So at this point, I'm going to let Carrie come talk a little bit about what she was, or some of the research she found through her assessment in Longmont, and talk about implementation.
Okay, thanks, Nick, for your introduction. So in regards to non-smoking policies, I interviewed some of the property managers through a phone survey to assess, to determine whether or not they already had a non-smoking policy for their apartment complexes. And one of the Longmont testimonials from a property owner with Hoover Community, her response was, the benefit of a smoke-free facility is the improved health and wellness for all of those who live and work at our facility. She also quoted that the initial impact for going smoke-free on their residents was twofold. For those who were smokers, they resisted the change in policy, and of the 5, 3 chose to move to other residences. 1 person quit, another still drives, and she smokes while in her car. For the rest of the residents, the impact was just the opposite. They felt safer, and they felt the air they were breathing was healthier for them. And in my phone survey assessments, these are the statistics that I've found so far. As of September 1st, 2009, the Longmont Housing Authority has 172 units in 3 affordable housing communities that are now non-smoking. The Boulder County Housing Authority has 135 units in Longmont that are also smoke-free, and 245 units throughout the county. I also was able to talk to property managers at the Mountain View Plaza and St. Vrain Manor, Hoover Manor, and the Grandview Meadow Apartments, and these are all non-smoking communities. So in regards to enforcement of a no smoking policy, this is rarely needed, according to the National Apartment Association. Their quote was, "Enforcement is not a problem, and few owners experience backlash from residents after implementing a no smoking policy." This 51 unit in Colorado Springs, Section 8 community, became smoke-free in February 2007. When this particular community went smoke-free, the community administrator, Monica Slemskowski, quoted that no residents complained and no one moved out, and since then, our waiting list has grown. Some enforcement tools that you can use to help that we recommend that you can use for implementing a non-smoking policy is you can put together rental agreements and lease language that clearly state the policy for the building, units, balconies, and common areas. You can also use signs in and around the building, remind residents and visitors of the policy, as well as designate outdoor smoking areas, such as not allowing smoking between 15 to 25 feet from any part of the building, and also away from all windows and doors. And you can find a model lease on this website. It's mysmokefreehousing.org. We also recommend that you can implement no smoking policy by starting with a management decision. And this means that you can conduct a survey to determine resident preferences. You can educate your residents about the dangers of secondhand smoke. You can communicate the policy through meetings in person and in writing. You can adopt lease rules and require residents' initials, communicate consequences of policy violations, draft a good lease language by consulting an attorney, limit grandfathering to no more than a year, provide smoking cessation information and referrals, and talk to other landlords who have implemented policies such as this. And a sample survey can be found also at mysmokefreehousing.org. So when talking to your residents, these are a few that you can use. Indoor air quality will be healthier for everybody and protects everyone from the exposure to secondhand smoke. You can also emphasize that reduced fire risks increases the safety of residents and families. One of the statistics is that 5% of fires that start in apartment complexes are from smoking. So you can bring that point up to your residents. People who smoke are welcome. They will have to step outside and away from the building to smoke. Less building damage may help keep management rental costs stable. And you can also tell them about the Quit line and other resources that are available at 1-800-QUIT-NOW or at www.myquitpath.com. Landlords also tend to like using Take It Outside as a part of their messaging to residents when it comes to smoking. And if you are a property manager with a condominium, we recommend that you can work with your HOAs by reviewing government documents and educating the homeowners association board and make a proposal so that owners may have to vote and approve any rule changes. And you can make changes to the governing documents and file them with the appropriate governing body. Signs are also a great idea for keeping the air clean. You can use advertising to attract residents who desire a non-smoking environment. You can communicate the policy to prospective residents, visit the property and perform inspections, and also you can maintain good signage at all times. And these signs are available for free at these website, stepitems.com and gaspforair.org. Oh, sorry. Those are, it's gaspforair.org, gaspforair.org, and then stepitems.com. Yeah, items.com. And here are some Colorado web resources on help to implement no smoking policies. These include mysmokefreehousing.org, mysmokefreehousing.com, and smokefreecolorado.org. In Boulder County Public Health, we are here to help, and we can provide you with resident surveys and implementation steps, sample policies and educational materials, model smoke-free lease addendums, and also quit smoking resources and information. So we can provide these resources to you for free. So next I'd like to introduce Tanya Martinez. She's the property manager of the In-Between, and Tim Racco, he's the case manager at the In-Between as well. They will be talking about implementing a smoke-free policy and their experience with that. Thank you.
Hi, I'm Tanya Martinez, and I'm with the In-Between. I am the property manager. And Nick Robles and his team were very helpful when we started implementing the non-smoking policy. But first, I'd like to tell you who we are. That's the In-Between. And let's see. Okay, who we are and what we do. We're a transitional housing facility, and we provide transitional housing for a period of up to 2 years with intensive case management. And the goal of our program is to help residents achieve self-sufficiency within those 2 years. We serve individuals and families. Our facility has 3 buildings, totaling 51 units. The units consist of SROs, 1, 2, and 3-bedroom apartments. Our buildings are located at 250 Kimbark Street, 1901 Terry Street, and 1913 Terry Street. The residents served range in age from homeless teens through the elderly. The why and how of making the decision for our buildings to become smoke-free. We utilized the survey that Nick's team provided, and the results, they spoke very clearly. 78.8% of the residents reported that they are non-smokers. 84.1% of the residents reported that they do not allow smoking in their units. 63.6% reported that smoke intrusion into their units was offensive and caused them problems. 63.5% reported that medical conditions of their own or of a family member were made worse by the exposure of secondhand smoke, and 66.3% reported that they would support a smoke-free policy. Now I'm going to introduce Tim Rocco, and he's going to tell you how we utilize the data.
Okay. Thank you, Tanya. Okay. So change is hard, and however, at the time, before I mention some of the information that's up here, at the time when the survey was done in summer of 2008, about 45% of the tenants at that time were smokers, or the units had a smoker in them, and so that's kind of interesting to note based on some of the data that you were seeing. One other little piece before I continue too much further. In regards to the information that coming, we have samples of those things actually right out in the lobby if you wanted to see what we utilized, both memos that were given to tenants along with lease addendums if you wanted to see what we utilized. So they're available for you out in the lobby. We did send memos shortly after the resident survey was done and compiled, stating that on October 1st there would be we would be launching smoke-free housing, and so that it was roughly about 2 months in advance of that date that the first letter was sent out, and then a reminder letter was sent out again shortly before October 1st, once again, just to make sure the point was getting across, was received. Also, part of that too is we set up designated areas at the 3 different buildings that Tanya had mentioned, something like this, and all of which are more than 20 feet away from the buildings. And And then one other piece too, in conjunction with all of this and talking about obviously a lot of good reasons why to have smoke-free buildings, we did offer to all the residents, for those who were interested through the American Cancer Society, opportunities for education if they were interested, if they were smokers and wanted to stop smoking. So that was made available to people as well for no cost and free for our residents. For those people who were smoking at the time when we made the changeover, they had an option to be grandfathered in for a period of time. And you just heard that mentioned that as a guideline. In our case, our experience was 3 months from October 1st until January 1st of 2009. At that time, in January 1st, 2009, everyone then had to abide by the new policy. And talking about policies and consequences therein, and again, you can see a sample of this out in the lobby. For those people that we found or were reported to be using, we did have some criteria, and that took some getting used to. And even still today, there's occasionally we have some problems with that. But a written notice was given if there was suspicion or reason to believe that there was an offense happening with smoking. And then the second offense would be $50 fine. And to date, there hasn't been anybody that has gone to the third step, which is an eviction. So generally, or obviously, people after the first or second notice are able to then utilize the area that we've set aside.
You don't have to prove that there's no preponderance of evidence?
The question was, do you need to prove, or is there some evidence there that you can then follow up with a letter and offense? I don't know. Did you want to address that yourself as property manager? Mm-hmm.
If we get an allegation that somebody's been smoking within their unit, what we do is an inspection and look for evidence of smoking, and usually we'll find it. Very hidden, but we'll find it. We found coffee cups with water and cigarette butts in it, covered by a book. Sometimes we'll find a lot of odor controlling devices, Febreze and candles and what have you to try and mask the odor. But we never just act on a report. We always look for evidence, and that's when we go to the full offense and either write a letter or give them a fine.
And also, too, just walking in the unit usually is a dead giveaway as soon as you step in. So again, we have never gone to the third step with this since 2008. Now, as far as challenges and rewards of doing such a thing and converting units to smoke-free, certainly part of it is, again, with change being difficult sometimes, there was a resident buy-in was important, and that's why the survey was done. That's where all those other efforts were made to communicate clearly what was going to be happening. And again, talking about those that feel that smoking is a right and getting kind of past that myth, so to speak. Enforcement and follow-up with the violations, we just mentioned that. One of our challenges at the unit at 250 Kimbark is a little bit of the problem is about the layout of the building. We have a courtyard. It's shaped it's kind of in the shape of a U, and the courtyard would not be a good place to have, nor is it really 20 feet away at any point from the building. And so we had to set up a designated smoking area that was maybe not as convenient as you might have in a traditional building. And so that's one of the challenges I think we have is the distance of which people have to walk or travel to be able to smoke. It's hard to get around that one. But certainly then again, talking about the rewards, healthier smoke-free environment, it's much easier at this point, the turnaround when a unit is vacant to prepare for new tenants coming in for, again, a lot of the obvious reasons that Nick went through. Fresh set of paint and clean the carpets, and for the most part that's what needs to be done. And reduced fire hazard, and obviously financially it's easier to maintain units like that too. So Maybe at this time I want to welcome or entertain questions that you might have, either for in between and in our process of doing this and converting to smoke-free, or maybe even for Nick, for that matters, right?
Excuse me, if anybody has questions, please let me give you the hand mic because we're recording this to put on the internet. So,
my question to you is, does it bring a different type of tenant to you that maybe is a more responsible person versus someone that is more carefree about smoking?
That's so hard to answer. I'm not sure if I could say either way, but for the most part, the vast majority of our tenants are very considerate of utilizing a smoke-free or designated smoking area and respecting the smoke-free building, and that still holds true. So, as far as our numbers changing, do we have less smokers? I'm not sure if that's part of your question, but as far as courtesy and whatnot, I think we don't have problems with that.
Do they tend to stay longer because it's non-smoking?
Ours is a little bit of a different situation in where Nick was talking about, being that we're transitional housing, we do have a cap and a maximum of 2 years that individuals and families can stay at they're not permanent housing, or it isn't permanent housing. So that doesn't really fit with our particular program.
I have a property not in Boulder County, but we have went non-smoking to different properties. And the issues that I have, and we've just became this way in the last 6 months, is we're having quite a bit of rebuttal about a few of the tenants that we do give them the rights to smoke outside the buildings, and the designated areas that we have set aside have not been ideal situations of keeping them non-smoking. And so now we see them smoking closer to the house, to the apartments inside the courtyards or whatever that we ask them not to. I did like your ideas that you had here of giving them a written notice, which we haven't. We just spoke to them, and then maybe a fine, and maybe getting them more involved in making the decisions also. I like that input you gave us.
Thank you. And I think that is really helpful because part of it is putting the responsibility on the smoker to be responsible about where they smoke and not impede the smoke on other residents. So I think having clear consequences in place would be very helpful.
Thank you. And one other additional piece to that as well. We do have regular community meetings, resident tenant meetings, and so if we have had similar things like that where we might have a group of people that are maybe edging their way closer to the building or whatnot, and so we'll bring it up, and we have opportunities to talk about that in a large group, just a reinforcement of, again, where the area is and expectations around that.
You addressed the HOAs for condominium associations. I wondered if you had any knowledge of a specific place where there's language we could use to adopt for an HOA, or if you have any example where you know it's been adopted in a building where we have individual unit owners, so the HOA has to, or the board or directors has to pass the policies.
Yeah, I'll have to double check with Pete Bialik from GASP, he's actually in charge of those websites that Carrie had mentioned where you can post smoke-free listings, and he also, he's monitoring, but I know there's one condominium in Colorado that has gone smoke-free, and we've tried to work with others, but because of the vote requirement to get about 67%, none have actually arrived to the process of actually voting, so I'll have to follow up with that. If I could just say a couple more pieces. On the table we left examples of some of the educational pieces. It's English one side, Spanish on the other, and it talks a little bit about, or really the talking points for residents as to why you would consider going to implement a non-smoking policy. Also, outside on the table, we have examples of the Units magazine. They featured smoke-free housing throughout one entire magazine, and we were able to reprint the articles pertinent to smoke-free policy. So if there's no more on the table, please email me, and I'll be able to send as many copies as you need. And also, we're going to be handing out right now just a little, I guess, overview of some of the pieces of information that we've covered that have the link or the website information also, just in case you want more information. And also just one other point, of course, we work I'm in the job of tobacco prevention and education, but I just also wanted to reiterate that we're also really here to support these policies that help protect people from secondhand smoke exposure, but also to help those that want to quit smoking. So with the in-between, our tobacco cessation specialist, like Tim had said, help facilitate some of the classes, and we provide information, and also anyone can receive the free nicotine patch and telephone coaching over through the Colorado Quit line.
When you have a place outside the building where you allow people to smoke 20 feet away or whatever, do you provide any kind of protection against the weather?
Yes, we do. We have a canopy during the summer. However, it did break midsummer, or what was it, like September, maybe? Got wind damage in September. But we are talking about getting a permanent canopy along with some portable heaters for the wintertime.
So did you have the canopy in the winter as well?
We had it through September when it got wind damage. So no, we did not have any protection this winter, but in the past they always have.
And do you have a place for them to sit?
Yes, we do have a picnic bench where they sit, and we provide ashtrays and buckets and trash can and the whole
Okay,
bit.
and the people don't complain that there's no protection from the strong winds and the snow and sleet and hail?
That's one thing we haven't got complaints about, surprisingly, but no.
Okay, thank you.
Uh-huh.
Thank you, Nick, and thank you for those from the in-between for giving us that interesting information. Our next speaker tonight is Judson Hite. Mr. Hite is a local attorney with 20 years of experience in private practice. He graduated from the University of Michigan in 1988 and worked in Chicago for almost 10 years as a corporate environmental attorney. He's worked another 10 years in Colorado as a real estate construction and land use corporate and litigation practitioner. And in between, he built houses. Judd's clients range from individuals to small and mid-sized corporations. He has also worked closely with legal departments of larger corporations and major metropolitan governmental entities. He's licensed to practice in Illinois and Colorado, admitted to the federal court in both jurisdictions, and is presently on the board of directors of the Boulder County Bar Association. He served as the business laws co-chair from 2004 to 2008. He resides in Longmont, and he says here he also enjoys golf and skiing.
Is this Tanya or Tim?
I'm going to be passing out an outline for Mr. Judge's talk while he's talking.
So should we do? Yeah, I'm sorry, there was an outline that was prepared, but there was an awful lot of material out front, and I don't know if anyone was able to find it through the mess, but I'm gonna try to follow that. It also has my contact information. I recently opened an office here in Longmont, which I like. So again, thank you, Nick, Carrie, Tanya, and Tim, for your presentation. That was informative. I am not a medical marijuana advocate. There are an awful lot of attorneys out there that are. I'm not that guy. I'm not a card carrier. Don't take payment in kind. I am, though, fairly well versed in the Colorado constitutional amendment that authorizes the use of medical marijuana, as well as what the state passed just earlier this week in terms of its new regulatory scheme, as well as several local zoning initiatives. I first got involved in this issue a year ago. I had forgotten that 10 years ago this initiative had passed, that medical marijuana has been legal for the last 10 years. My first medical marijuana client, and I refer to this as MMJ a lot, my first MMJ client was interested in my experience of having sued Boulder County over the Cemex tire plant, as well as on behalf of a guy who runs a t-shirt business as a home occupation. And I've also done some stand-up work in connection with getting some land use proposals together. She wanted me to approach local law enforcement to determine what their enforcement policies were going to be. At a time, again, about a year ago, when the local DA was writing letters to the editor of what he would or could or should do and what was or wasn't happening. So in connection with my homework in getting ready to have that meeting, I'm going to share with you what that homework resulted in. I've also, from that initial foray, done an awful lot of leasing negotiations and work, which I think is going to be very, well, germane to what your folks' practices are. So with that, I start with the Colorado Constitution. Amendment 20 is what this voter initiative moniker is known colloquially. It's codified, or the medical marijuana provisions of the Constitution are codified at Article 18, Section 14 of the Constitution, if you care to look it up. Though it's been in effect since 2000, it's largely and pretty much exclusively been underground. That all changed in February and again in October of last year, 2009, with the Obama Justice Department's announcement that its enforcement of the Federal Controlled Substances Act was not going to be a priority with respect to MMJ activities that were being conducted in compliance with, there are now 14 states. If there's MMJ activity that's in compliance with state law, the Federal Department of Justice is not interested in prosecuting. Not interested. What the Justice Department does is more or less turn a jaundice, but not a blind eye on medical marijuana activities. To wit, you might have remembered that last winter there was a Highland Ranch resident individual who got on television and flaunted about his living the life of raising medical marijuana and how much money he was going to make. That same local television station filmed him the next day being led away in handcuffs by the DEA. So it's not legal federally, and you need to remember that in connection with your landlord activities. What Amendment 20 does is allow patients, sick people with debilitating medical conditions and their primary caregivers to engage in the medical use of marijuana. So a lot of relevant definitions that you need to understand there. The conditions have to be medically diagnosed. They include cancer, glaucoma, HIV/AIDS, cachexia, which is a wasting disease, severe pain, which I think is the most popular prescription, nausea, seizures, and muscle spasms. So a person who's diagnosed with that medically, and the doctor concludes that the use of marijuana might alleviate those conditions, has passed the first hurdle of being able to engage in medical marijuana. What is engaging in the use of medical marijuana? A person can acquire, possess, produce, use, and transport marijuana and paraphernalia. What's interesting is it allows for the acquisition. It does not allow for the sale. which, you know, I've been in numerous arguments. The sale and the acquisition are two sides of the same coin. My argument is, you know, you're allowed to acquire it, but you're not allowed to sell it. And people explain to me, well, lawyers argue with me, well, that's absurd. How could you only one half of a transaction be legalized? The only thing I have to say is that there's an appellate court judge that identified exactly the same nuance that I identified in a case that's been reported. And anyhow, his decision was, you know, this law is this law's only half baked. So it's a weird nuance that needs to be, you know, that practitioners need to be aware of. Then you get down to the definition of what is a primary caregiver. It has to be an individual, 18 years or older, who is not a patient or a physician. And that person must have significant responsibility for the well-being of the patient. The particular appellate court case I was referring to is People v. Clendenden, which was a case that arose out of the city of Longmont. Longmont Police Department arrested a woman, Stacy Clendenden, for, in their words, improperly distributing medical marijuana. And what the Court of Appeals case held is that a primary caregiver has to have more responsibility for a patient's well-being than simply purveying pot to that person. So that's an interesting point to file away as well. Amendment 20 creates an affirmative defense to state criminal laws if a physician has made the diagnosis that a patient has a debilitating medical condition, and the patient and the caregiver are collectively in possession of no more medical marijuana than is medically necessary. The Amendment 20 also establishes that 6 plants, half of which are in flower, and 2 ounces are per se medically necessary. There's also an exception to the criminal laws for a patient and caregiver who are in possession of a medical marijuana registry identification card. That registration card is issued by the State Board of Health. The State Board of Health establishes and maintains a confidential registry. It accepts applications and issues serially numbered cards to patients who have been, you know, diagnosed as having these conditions. This confidential list can be accessed by law enforcement to check. I mean, they can't check. They have to call into the Board of Health. The Board of Health then confirms back whether or not a particular individual that law enforcement may have stopped and has presented this card, whether or not that person actually is a registered patient. The registry also is where the patient-caregiver relationship is established. You have to state in writing who your caregiver is going to be if you're a patient, and issue that writing to the State Board of Health. That's how caregivers are established. The dispensary business model buds from caregivers identifying and having a number of patients designate them as caregivers. If each patient represents 6 plants or 2 ounces of marijuana, if you get enough patients to designate you as their caregiver, you can open up a storefront and sell your patients medical marijuana at retail. At least that's the business model. The Clendenden case, though, did inform folks that you had to do more than just simply sell marijuana. So you also see a lot of dispensaries that have yoga, Pilates, acupuncture, massage therapy, activities associated with the purveying of marijuana. The issues that arise or problems that come out of the dispensary model is that, again, as I identified earlier, Amendment 20 only authorizes the acquisition of marijuana, not the sale. And again, the patients that you're selling to have to have designated you as their caregiver to at least try to pass the sniff test of this being legal. Patients or card-carrying members walking in off the street, which is kind of how the business works, in my mind, are not truly your patients, and you're not truly legally allowed to sell to them. Many of these dispensaries then became vertically integrated. If you could establish a grow site to which you were, you know, supplying yourself marijuana at cost, you could kind of cut out the middleman grower. There are numerous growers nonetheless. that ramble from dispensary to dispensary, that supply them with product. In my mind, it's completely an illegal drug sale. There are numerous other folks who are creating foodstuffs and oils and salves and tinctures. They're basically reducing medical marijuana to an oil or a paste and then infusing it into other foods. Those folks, too, are traveling door to door and purveying that material to dispensaries. There's ice cream, there's soda, and the traditional cookies and brownies that people are making, and it's being sold. So that, in a nutshell, is Amendment 20. Just this Tuesday, the state General Assembly passed what's called House Bill 1284. I only have the May 6th copy of this thing. I haven't been able to find the May 11th final version, but I understand that the final version pretty much is exactly what my May 6th version looks like. What HB 1284 did was create 3 categories of licenses. There's a medical marijuana center. That's a dispensary. There's a medical marijuana infused product manufacturer. That's the cookie maker. And then there's an optional premises cultivation operation, and that's a grow site. What this new law does is uncouple all of those activities from this patient-caregiver relationship, which was the only way you were able to otherwise engage in medical marijuana activities under Amendment 20. This new law now actually prevents caregivers from becoming licensees of these 3 different types of activities. It also now limits caregivers to having no more than 5 patients. It completely kind of turns the dispensary model that had been in existence on its ear. This new law creates a 2-tiered licensing system. It's premised on the liquor licensing laws of the state. There's a local license and a state license that have to be applied for and obtained to become legal. It also, though, allows locally for a local government to ban entirely whether or not it's going to participate in this and allowing these activities to take place at all. The nuances: a medical marijuana center may sell to patients and caregivers and up to 30% of its product to other licensees, to other centers. Though it also must grow or produce its own product. So it has to be engaged in this optional premises cultivation operation. It's not really optional, it's mandatory. If you're going to be engaged in running the center, you're going to have to grow your own weed. And 70% of it you have to sell. 30% of it you can sell to others. An infused products manufacturer must have a contract with the center, with a medical marijuana center, for the acquisition or purchase of product, which also, kind of interesting to me, that contract also has to specify how much infused product is going to be made from the raw material that's being purchased. That's interesting. An infused product manufacturer, though, also can have this optional premises facility and can grow its own material. But in that instance, the infused product manufacturer cannot sell their raw goods to anybody else. They have to grow it and use it. And grow sites can only be owned or operated by medical marijuana centers or manufacturers. So it puts it all under one rubric, so to speak, the whole activity is under one rubric, and cuts out the primary caregiver relationship. This law also is going to require disclosure of all persons who are going to be involved in the medical marijuana business, requiring background and fingerprint, criminal investigation checks. There's a $5,000 bond requirement to make sure that medical marijuana facilities collect appropriate sales tax. Remittances, which I find somewhat discriminatory. I don't know that that's going to hold up. It also creates $1,000-foot buffers from where these facilities are located to any school or drug rehabilitation center, and it also requires that the facilities maintain open books and records. And just when I'd thought I'd done all of my homework in preparation for this seminar, the county announced on Wednesday that it too was going to adopt a new layer of regulations through a text amendment. So any of you who are in unincorporated Boulder County, there's a new set of regulations which is going to regulate something called now a medical marijuana center. They use a name purposefully similar to what the state regulation is. And that's going to allow, well, it's going to create a special zoning regulation for these facilities where medical marijuana is grown, sold, or distributed. They're allowed by right in the transitional business, commercial, light industrial, and general industrial facilities. One house is deemed to be incidental, inappropriate. They have to be 500 feet away from any other facility, 1,000 feet away from any school or drug treatment facility, and which is actually kind of convenient, if you're transitioning from a retail or personal facility into one of these medical marijuana centers, you get to avoid going through site plan review. So that's my brief tutorial on the black letter law of medical marijuana, which leads into a discussion of, what does this mean for the landlord-tenant relationship? How's this going to affect your business? My first analysis is to go back into zoning. There are there's various legislative initiatives towards local zoning control over medical marijuana. The city of Centennial actually tried to ban dispensaries because the medical marijuana activity is illegal under federal law. Their ban was overturned because it's legal in the state of Colorado. You can't ban an activity because it's otherwise federally illegal, at least at the trial court level, at least right now. That's as far as that litigation has gone. Many cities have also enacted temporary bans or moratoriums. The city of Longmont has extended its moratorium until July 1st of this year. None of those bans, to my knowledge, have been challenged, though I suspect that taking a time out to study and craft regulations to try to respond to this burgeoning field will probably be upheld. Under the new state legislation, local governments are also entitled to, totally opt out of allowing these medical marijuana centers, infused product manufacturers, or grow facilities to exist in their jurisdictions. Other cities, Boulder, have embraced the activity and fully regulate it, and will probably generate a significant amount of revenue off of it. The Boulder regulation, which I won't go into, is very comprehensive. And goes online next week. Typically, what you're going to identify as a landlord when you're looking at whether or not zoning is going to permit this activity, if you're going to go down that line, is you're going to find that, what zoning does, it regulates distances between facilities and how many facilities can be near one another. It regulates the distance between a facility and schools or these drug treatment facilities. It also is going to, limit the activities to certain types of zoning districts. It's going to limit the size and probably impose safety standards on the activity. You probably also, well, at least used to be, were required to be mindful of these clendenin activities. You had to do more than just sell pot. Now, under the new state law, you can probably just sell pot. So if you were going to be engaged in previously, if you're going to be engaged in medical marijuana, you had to have this yoga activity associated with it too. So those two activities had to blend together and be legal under the zoning. So I still think that if you're going to, work with a tenant who wants to be engaged in this, you first need to make sure this is going to happen. This is going to be permissible in the zoning district where your facility is located. If you're simply running to a residential tenant, there's a tension. There's certainly a freedom to contract. I think the question was raised as to whether or not medical marijuana would be a right or something of a higher ground than tobacco smoke is because it is of this constitutional nature. There's clearly freedom of contract, caveat emptor. A landlord could prohibit the use of medical marijuana in his facility, and a tenant could contract away his rights. Though, at the same time, speaking out of the other side of my mouth, it's a constitutionally protected right. A lease is a matter of state law. State law, allows this activity to take place. So I think at the end of the day, personally, my sense is you can contract away your constitutional rights, some of them. And your right to engage in medical marijuana is probably one of them. The issue, though, is more germane when a landlord identifies now under his existing lease that his tenant is engaging in medical marijuana activities. I think there, the parties certainly weren't intending, I think when they went into the lease arrangement, that that medical marijuana was an activity that was going to be taking place in this facility, even though it might have been otherwise legal. So that's going to be an interesting case if you're going to be involved in one. This tension between, this freedom of contract and what were the parties intending, that, the activities would not include illegal, and it's still illegal federally, engage in medical marijuana as opposed to this constitutional right. How many people are residential landlords versus commercial, or both? Who's both? Who's residential? Unfortunately, the rest of my discussion is more or less commercial. Maybe some of these points will cross over, though. The first thing overall that you might want to consider if you're going to allow somebody to become involved in medical marijuana activities, it's still illegal federally. And under federal law, 21 U.S.C. 856, it's a crime to open, lease, or use any place for the purpose of manufacturing or distributing a controlled substance. Medical or marijuana is a Class 1, Schedule 1 controlled substance. If you manage or control as an owner and then knowingly rent, lease, or make available with or without compensation any facility for the purpose of the manufacture, storage, or distribution of a controlled substance, you risk forfeiture of the property and a $2 million fine if the feds want to enforce. That scares a lot of people. In the background of the Obama administration's announcement that it's not a priority to enforce the Controlled Substances Act against people who are in compliance with state medical marijuana laws, you might get some comfort from that. It's also extremely good money right now. I think tenants are paying top dollar to get into a warehouse to be able to grow marijuana, or to get into a storefront to be able to sell it. So, I mean, against that backdrop, you need to be aware of the fact, lose the property and be subject to a $2 million fine is the worst case scenario. Other terms in drafting your commercial lease, you might want to consider defining what is the permitted use. You got to tie that permitted use into your compliance with laws section. That permitted use by definition isn't going to comply with federal law, so you need to carve that out or address it in some way, shape, or form so that the tenant doesn't sign a lease that he's immediately in violation of. You should consider whether or not obtaining the requisite permitting is going to be a precondition to the commencement of the lease term. It's complete frustration of purpose if the individual can't get the requisite permitting to be able to engage in the activity that he thinks he's going to be engaged in. You also need to consider whether or not, if there's a change in law or a change in the enforcement of law, whether or not it should be grounds for an early buyout or termination of the lease. You don't necessarily want to continue down a lease arrangement, especially with this forfeiture penalty, if the activity becomes illegal or the enforcement becomes more prevalent. Next are tenant improvements. Generally, there's a TI allowance, or the landlord approves what kind of activity or improvements are going to happen. There are some unique issues to medical marijuana businesses. Security systems. Most tenants are going to want to install cameras, recorders, motion detectors. They're going to want to install secured foyers with electronic entry systems. I call them Detroit teller windows, but bulletproof glass to keep people away from the goodies until they're buzzed in. Reinforced doors, windows, bars on your windows. You need to consider whether or not you want, if you have the infrastructure or the wherewithal to allow that to happen. Do you want that to happen? Do you want bars on the window? Also, most of these most of these individuals have huge floor safes in which they keep their product and money. There are some structures in Boulder that, are old houses where the flooring isn't necessarily adequate to hold that safe. So there's some improvement that needs to be done to be able to at least even just to hold the darn safe. So you need to assess these requirements and capabilities of the structure, and you need to allocate responsibilities and liabilities for these improvements. In grow sites, those facilities are extremely reliant upon dependable power sources and or backup sources. Typically, the landlord is, generally taking on responsibility for the at least the providing or the drop of the electrical source or the power source, the tenant responsible for paying for it. The foreseeable consequential damages of a power outage or a capacitor blowing, that's significant. A grow site can, a grow can be several $100,000 worth of profit that's lost. Lighting and power usage are also high. There's extensive lighting. Water quality is very important. Reverse osmosis filtering treatments. Generally, those units are big. Generally, they're expensive, and generally the tenant wants to take it with him. So whether or not that's a trade fixture versus an improvement are things you should discuss and negotiate up front. Collateral considerations. These facilities are theft targets. Whether or not your hazard insurance premium is going to go up, you should investigate with your carrier. And the cost of that hazard insurance you might want to share with your tenant. I have seen comprehensive general liability policies for dispensaries, and I've heard reports that there's actually coverage available for the products that are being sold, but you might want to get a CGL policy for your tenant. Tax lien complications, seizures for non-payment. The state and the localities are now very, very interested in generating tax revenues from these facilities. Their books and records are now going to be subject to audit or extensive audit. You might want to, without becoming a joint venturer, make sure that those tax payments are being made so you don't have to deal with a seizure. Off-site, your neighbors might complain of odors. There's increased traffic. The clientele that frequent these facilities are unique. And sometimes clients also or tenants also want to have armed security. You need to consider whether or not any of that is appropriate for your neighborhood. And then finally, I guess I'll share some of my own war stories, some specific issues. I was involved with a residential tenant growing for his own use, and his landlord found out and wanted to evict him. And they were claiming that it was because it was a violation of federal law, and we had exactly that argument as to whether or not the lease was a creature of state law, and state law allows this activity versus the intent of the parties. Ultimately, we settled. Nobody went to court, but that's where that issue comes up for me. Another one, grow operation, the facility in which it was located came up for sale. And the due diligence of the buyer, the environmental inspections, the facility inspections, all of that had to take place in an environment where my client didn't want anybody looking at his grow activities. Those are concerns that you should think about up front. And then finally, in a commercial condominium setting, the covenants granted multiple exclusions, just one restaurant, just one coffee shop. Well, two competing medical marijuana businesses opened up, and one of them wanted to come up with a retroactive exclusion. That certainly wasn't going to work, but if you're running a commercial condominium or any condominium, you might want to consider amending your bylaws to address this issue. So that's my presentation. Thanks.
What is the state's position regarding using residential for grow sites or even for themselves?
The state right now, the program is set up so that you have to get local zoning approval to do that. In the city of Boulder, you're not going to be able to do any activity at the residential level. Other municipalities, it's just, can it be a home occupation? In the county, it could be. Certainly could be. I was just talking to a client today with an infused manufacturing activity, and she was worried about what was going to happen if the county adopted this regulation. And it's small enough what she does, could be a home occupation. So it's going to happen.
What if the tenant claims they're just growing for themselves, not as a caregiver? Is that also illegal?
That activity is probably not going to be subject to any regulation. If he's growing for himself, it's a constitutionally protected activity that you know is void of any criminal liability to him. As between he and his landlord, whether or not that's proper, that's where your lease needs to be looked at.
Thank you.
Yep. Microphone.
Can we just add it into the lease specifically that we do not, like basically there's no marijuana in the home?
No cultivation, no dispensing.
How about usage?
Yeah.
Because I've had 3 since January ask me, and I don't have it in the lease today.
Well, it depends on how you come out on the issue. If you want to not have that go on, I would put that in my lease. None of that goes on.
And are we opening ourselves up to be sued for that?
I wouldn't think so, because again, my view, or I guess my opinion, and this is not an attorney-client relationship, so you can't rely on it. My assessment is that there's freedom of contract, and this particular constitutional right can be contracted away. I could be wrong.
All right.
We also had somebody ask if they could do a grow operation in a residential environment, and my primary concern was mold. Is that has environmental issue in a residential environment been brought
Well,
up?
there are an awful lot of collateral issues. Yeah, mold's one. The power usage. The type of lights that they use now apparently aren't as flammable as others are, but I mean, it's a friable material. If they dry out the plant, that could catch on fire, so there are fire hazards associated with it. Large power usage, you know, raising the interest of law enforcement, because your power usage is going to be high. You're going to create kind of a weird, you know, infrared footprint that is looked at. So, you know, there are collateral concerns.
Do they not have to disclose that when you are making out your lease? And in your lease, you have a drug addendum that says you're going to be evicted if we find you smoking or using drugs of any kind immediately. They sign that, and then you find out they're medical marijuana.
Well, I'm not exactly familiar with your addendum, but I would assume that if your addendum said the use of any, you know, and again, it depends on the wording. Illegal drug? Well, that's not necessarily an illegal drug. It's a legal drug. If he's got his card, you know, he's legally using. So
But he doesn't have to disclose it, or she?
I
initially.
wouldn't say that. No, there's no.
Like when you're signing the drug addendum, you don't say, "Oh, by the way, I have a medical marijuana certificate." They don't have to do that?
No, they don't have a fiduciary obligation to disclose anything, to my knowledge, no.
Okay. Can you tell them, okay, it's legal, you're allowed to, but can you say no smoking, only ingestion?
Sure, you could do that. Again, under my view that these are contractually waivable rights.
Is one form more effective than the other?
Form of ingestion?
Smoking versus...
I have no idea.
And how'd that come out when you said it was settled?
My particular
The
case?
residential.
My
yeah.
client decided to move his grow activities to another place just to avoid the confrontation.
My question was, along with hers, about if we put in no smoking, does that include marijuana, or is that...
I would assume that no smoking means no smoking. Tobacco, corn hair, you know, anything.
Catnip, all of those things. And just a comment to those of you who are concerned about people growing in mass quantities. I attended the crime-free program that the police department put on, and one of the things that they talked about was a home here in Longmont that they went into, and the entire home, entire bedrooms, everything, was being used to grow marijuana. And they went down in the basement and people collapsed because they pump, I believe it was carbon dioxide, into the home. And that does interesting and negative things to the building. So it's something that you need to consider, and I'm sure that if you called the police department, someone there would be happy to share the information with you on that type of thing. They showed pictures, it was astounding. So, as an aside, thank you.
If I understand right, if we put it in the lease, we can prohibit the growing of marijuana, or we can prohibit the consumption or smoking of marijuana. That's a choice that we have the right to make in a lease agreement.
That is indeed my understanding, sir.
Okay, thank you.
And I guess I would probably suggest that if you want to prohibit that, you should add an explicit clause that says that with the tenant's initial next to it. Maybe not that far, but put that in your lease explicitly.
Can't the tenant claim it's a constitutional right? It's a medication. I mean, it's
Again, yeah, it's a constitutional right, and yeah, the enforcement of a lease is a matter of state law, but there are certain rights that you can contract away, and probably slavery isn't one of them, but I think the use of medical marijuana at the state level is.
Thanks.
That's, you know.
Anybody else have questions for Mr. Hite?
Thank you.
Thank you all for coming tonight. I want to remind you again, if you want to be on our mailing list, our email mailing list for notification of other upcoming symposiums and activities related to landlords, please leave your email address up there. Please take a copy of our new landlord handbook that's up on the front table, and thank you all for coming.